on to our next section, I'm going to bring on Maureen to talk about our WDI UK's position moving forward, and what we think in the UK we should be doing moving forward.
Tracey and I are both going to be talking about the WDI UK campaign, and it's involved. It's Northern Ireland and England, Scotland, and Wales are going to be involved in it, which we're calling Restore Safeguarding, End Sex Falsification. And by ending sex falsification, we mean getting rid of all recognition of so-called gender identity in law and in practice. So that would involve changing the law, repealing the GRA, changing the Equality Act and the Northern Ireland equivalent, which relates to gender reassignment. And we're starting this campaign this year because it's the 20th anniversary of the Gender Recognition Act. It had nothing to do with the election being called. We didn't know the election was going to be called when we first started talking about this campaign. It's a coincidence. So we're wanting to end all forms of sex falsification in law and in practice. We don't think this is going to happen immediately, and I certainly don't think it's going to happen in the near future. But what we want to do is to widen the conversation, to raise the issue of ending sex falsification. And I think there are more and more people in the UK who are now starting to argue for that position, and we're hoping to extend that and create more public awareness of the impact of the different pieces of legislation and the practice as well that's going on. It's particularly in regard to the safeguarding of children, of women from sexual violence, for example, and of vulnerable adults as well. For example, adults who need same-sex care, intimate care. So we are planning to campaign around that in various ways. And I'm going to talk about the existing law. A lot of you will already know about quite a lot of what I'm going to be talking about, I think, particularly in relation to the GRA, but I'm just going to cover it so that everyone's clear about it. And I'm also going to talk about the provisions in the Equality Act, which aren't quite so well known and haven't been so widely discussed in terms of possible repeal. So it's always been the position within the Declaration that there should be no recognition of so-called gender identity in law or in policy or in practice, that men cannot become women, and that the law shouldn't pretend that they can. Article 1 of the Declaration, and the Declaration is very much rooted in the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW. Article 3 of the CEDAW talks about taking appropriate measures to guarantee women the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. And we're saying that that has to include, and the Declaration says that has to include, the retention in law, policies and practice of the category of women to mean adult human female, the category of lesbian to mean an adult human female whose sexual orientation is towards other adult human females, and the category of mother to mean a female parent. And the exclusion of men who claim to have a female gender identity from these categories. That's a fundamental principle of the Declaration. And repeal of the GRA and the ending of other forms of legislation which promote gender identity follows on from that. So the law and policy that we're aiming to change, and we want to start debate about changing it, is the Gender Recognition Act 2004, which Sheila's already talked about. But we also want to remove the category of gender reassignment from Section 7 of the Equality Act 2010. That's one of 9 protected characteristics within the Equality Act. We'd like to see that removed because it's a form of recognition in law of the idea of gender identity and the idea that people can change sex or change gender. And the equivalent to that in Northern Ireland is the Sex Discrimination Northern Ireland Order 1976. And the provisions in that order are broadly similar to the Equality Act provisions. There's been less discussion about changing the Equality Act provisions in the UK than there has about repeal of the GRA. And it's also more controversial, even amongst women who advocate for sex-based rights, which I'll talk about a little bit. And we also want to remove de facto self-declaration of gender identity which is happening in practice across the public and private sectors, and has been for many years, largely as a result of behind-the-scenes lobbying by gender identity organisations such as Stonewall and other organisations as well. But that existed even before that form of lobbying, because it's been possible for many years for people to change their sex markers on driving licence, for example, and passports. They can't change their birth certificates in that way, but they can change other sex markers, and that is a form, effectively, of self-identification or self-declaration of gender in practice. And it raises a lot of safeguarding concerns, because it allows people with criminal offences to more easily hide their identities. That's one of the things we want to change. So the key Gender Recognition Act provisions, which most of you probably know, it enables a person to get a gender recognition certificate which will change their gender in law. Gender is used as a synonym for sex in law, and as Sheila's already discussed, there's never been any clarity about the difference between the two words. I suspect that was deliberate at the time. So they change their gender for most legal purposes, but not all legal purposes. And there are specific provisions in the Act which say that the Act will not have the effect in certain circumstances of changing someone's position in regard to their gender. One of which is Section 16, which is designed to allow men who are due to inherit peerages, so titles, to protect that. So if they have an older sister who gets a GRC saying that she's legally male for most purposes, she won't be legally male for the purposes of inheriting the peerage. The man will still inherit the peerage, which always goes to the oldest male in the family. So she won't become a fictional oldest male. He will still be the oldest male. So it's designed to protect a certain type of male privilege. That's one of the exceptions, which highlights, I think, how much of a fiction the Act is and how much of a fiction the people introducing it really knew it was from the beginning. And to get a gender recognition certificate, a person must have a diagnosis of gender dysphoria. Sheila's already mentioned the medical professionals they have to have that has to be supported by, so I won't repeat that. They must have lived in the other gender for at least 2 years. That generally involves things like using a name that's associated with the opposite sex, dressing in ways that are typically associated with the opposite sex, and so on. And their application has to be accepted by a gender recognition panel, which consists of medical and legal professionals. They don't have to go in front of the panel if they don't meet the panel. It's all done on paper. So those are the criteria. And if they are seen as meeting those criteria, they will be given the certificate. They don't have to make any physical changes to their bodies at all. There's no requirement for that. That's one of the reasons why people who supported the legislation trumpet it as being very progressive, because it was the first piece of legislation in the world to do that, to allow people to change their sex or gender in law without any physical alteration to their bodies. So maybe the penalists can get a gender recognition certificate very easily, and they often do. The protected characteristic of gender reassignment is contained in the Equality Act, as I said, and it applies to people who are proposing to undergo, are undergoing, or have undergone a process or part of a process for the purposes of reassigning their sex by changing physiological or other attributes of sex. No physiological changes are required, again. Protection on the basis of gender reassignment, which isn't the same thing as getting a gender recognition certificate, doesn't require a GRC. Equally, having this protection doesn't give a person the right to be treated as if they are the opposite sex in any particular circumstances. Although, because there's a lot of muddle about these two pieces of legislation, and there's a lot of confusion generated inevitably by creating a legal fiction that says people can change their gender or change their sex, many people believe that it does give them the right to be treated as if they are members of the opposite sex. And the pro-trans lobby groups have encouraged that. The purpose of this legislation is supposed to be protection from discrimination, for example, in employment and housing and the provision of different kinds of services, and also protection from harassment and victimisation. And it tends to, the cases that are brought under this Act tend to be employment law cases, very many of them. So its purpose is protection from discrimination and harassment and victimisation. So one of the issues that's come up in the debate around the Equality Act provisions is the question of, if that's removed, how can people who identify as transgender, whether you may accept their subjective identification or not, how can they be protected from genuine discrimination and harassment? Not treating someone as if they're the member of the opposite sex is not discrimination under that legislation, at least not in theory. But there are situations in which they might genuinely be discriminated against, such as being refused housing, for example. There are types of discrimination in employment, but that's a difficult issue, which I'm going to come on to a little bit more in relation to autogynephilia. And also they can be victimised and harassed, genuinely victimised and harassed. So many people have argued, well, it wouldn't be right to remove the protection from discrimination and harassment and victimisation. But others have proposed alternative ways of protecting people who subjectively identify as transgender from those things. So, for example, Alexandra Astoriti, who's a legal academic, has suggested that people who identify as transgender could be protected under some of the other protected characteristics in the legislation. Those are sex, age, disability, race, sexual orientation, religion or belief, and marriage and civil partnership. She suggested that those who are or who are perceived to be homosexual could be protected under the sexual orientation characteristic, that those who have a diagnosis of gender dysphoria could be protected under the disability characteristic because it's effectively an illness, although that's disputed by the trans lobby. And also that identifying as transgender could be treated as the equivalent of a philosophical belief. The philosophical beliefs are protected. If that was done, that would frame gender identity as based on an individual's subjective belief, and other people would not be compelled to share in that belief or to behave as if they shared in that belief by, for example, using the pronouns that person preferred, or in other ways pretending that they believed that person was actually the opposite sex. So that would frame identification as being transgender as entirely subjective. That's one set of proposals that have been made. WDI UK isn't advocating for those. We're simply noting those proposals as one possible solution to the problem of how people who subjectively identify as transgender, who are genuinely being discriminated against or harassed or victimised, could still be protected if the characteristic of gender reassignment was removed from the legislation. So I already mentioned there are issues around autogynephilia, particularly in relation to employment. And developing alternative ways of protecting individuals who subjectively identify as transgender from discrimination and harassment would need to take account of the ways in which the manifestation of some people's beliefs about their gender identity, so-called, harms others and potentially undermines safeguarding. Many men who identify as women or say they do, as we know, are autogynephiles, which is a paraphilia. And a man who acts out a paraphilia in the presence of other people is a safeguarding risk, particularly in relation to children and vulnerable adults, and also in relation to women in many circumstances. So if we were going to look at alternative ways of protecting people who subjectively identify as transgender from discrimination in employment, for example, we'd have to look at how we can both restore safeguarding and think about how employment law and practice and recruitment practices should deal with the issue of autogynephilia. And that's something we haven't really even begun to discuss. Discussing autogynephilia at all is something that is very difficult because many trans activists and pro-trans activists deny that it exists. They do everything they can to shut down discussion of it. And although we raise it, and women who are advocating for sex-based rights raise it, we haven't really looked in depth yet at what the existence of autogynephilia and the effect on people who are around someone who is an autogynephile, exhibiting their paraphilia, has on those people, particularly vulnerable people, vulnerable adults and children, and how employment practices can deal with that. I don't think we've even begun to really look at that, but that's something we do need to look at. If we're going to argue that people who subjectively identify as transgender should be protected from discrimination, which I think we should, I think everyone should be protected from genuine discrimination, then we need to look at what are the implications in relation to those who identify as transgender who are autogynephiles or who have other related paraphilias, which they are acting out or want to act out in public. Under the Equality Act, there are exemptions which allow men, including those who claim to be women, to be excluded from women's spaces and services if this exclusion pursues a legitimate aim and does so in a proportionate way. So the Act allows for the exclusion of males, or any males, from single-sex services like domestic abuse refuges, rape crisis centres, and so on, although there's a debate about that. And there's been a push by the pro-trans lobby to argue that those who identify as transgender should be able to be included in what are single-sex spaces. But the Equality Act does allow for them to be excluded, including those with the GRC. So some feminists argue that we can protect women's sex-based rights by strengthening these exemptions in the Equality Act and clarifying the meaning of sex in the Act so that it's clear that it means sex and only sex and does not include gender or gender identity. And I think this could protect some sex-based rights more effectively than they can be protected at the moment, but it won't protect them completely. I'm going to talk about some of the reasons why briefly. So there are some rights which are conferred by a GRC which can't be limited by the Equality Act exemptions. One very obvious one is that a male prisoner who holds a GRC and is therefore treated as a woman for most legal purposes can generally only be intimately searched in prison by a female prison officer. If he can't be persuaded to be searched by a male, which sometimes they can be, but if he can't be, he will be searched by a woman. On the basis, and if the prison service tried to say, no, you must accept a search by a male, he would potentially have a claim under the European Convention on Human Rights, under Article 8, which is the right to respect for private and family life, and also under Article 3, which is the prohibition of inhuman and degrading treatment and torture. He could argue that it is inhuman and degrading treatment for him, a woman, as he claims, to be intimately searched by a male. Now, if a woman made that claim, that would be completely reasonable. And it would be inhuman and degrading treatment. A man who's treated as a woman for most legal purposes can also make that claim. And so women, prison officers, are searching male prisoners, many of whom are sex offenders, and many of whom retain male genitalia. And that includes intimate searches, which is arguably a breach of the Article 3 rights of those women, but certainly a breach of their Article 8 rights, their right to privacy. So that's one of the fundamental contradictions between sex-based rights and the ability of men to obtain a GRC. Also, as long as the law recognises or pretends that people can change their sex or their gender, whatever terminology is used, there's a potential for legal challenges to any exemptions that are introduced. And a very good example of this, something that happened in Canada to Vancouver rape relief. A former male client of theirs who identified as a woman, they did provide counselling services to trans identifying males, but they don't allow males, whether they identify as a woman or not, to provide counselling or other services to women as part of their service. Having gone through the counselling, he wanted to become a counsellor and they refused. So he took them to court, and eventually the case went as far as the Supreme Court in that particular part of Canada. And the Supreme Court said that Vancouver Rape Relief, in excluding males, all males, from providing services, were acting within the human rights law. So it was lawful for them to do that. That was a Supreme Court decision. But still, the trans lobbyists who were effectively trying to close them down if they wouldn't agree to allow males to provide counselling services to women, then started a campaign to persuade the local authority who funded the service to withdraw their funding, which the local authority did. So their funding was taken away. So the local authority was clearly captured by gender identity ideology. The activists involved in this campaign went on for years. They harassed Vancouver Rape Relief for years in different ways. So they got their funding cut, even though the Supreme Court had said what they were doing was lawful. Vancouver Rape Relief are still going, as far as I know. They certainly continued after that happened by fundraising and so on. But it's a very good example of the ways in which women-only services can be harassed and even potentially shut down, even though they're operating lawfully, as long as there's still a belief, a widespread belief, supported by law in whatever ways, that a person can change their sex or their gender, whichever terminology people want to use. So as long as gender reassignment or the possibility of acquiring a new gender, which is the language of the Gender Recognition Act, still exists in law, as long as that does exist, it's unpredictable what the effects of any exemptions which are designed to protect single-sex services will be. They can always be challenged, or can often be challenged, and lawyers will find ways of challenging them. So some feminists see keeping the gender reassignment provisions in the Equality Act, keeping some form of recognition of gender identity, whilst strengthening sex-based rights as a kind of balancing of rights. They see that as fair. But the legal recognition is a fiction, which is fundamentally incompatible with the sex-based rights of women and also with the safeguarding of women, of children, and of vulnerable adults. And the inclusion of men in the category of women in any form, I would argue, is not a legitimate right of those men and shouldn't be seen in that way, however they identify. It's an unjustifiable entitlement. So what they're doing is wanting not only to identify as women in their own minds, they're wanting to force everybody else to accept that identification is real and to act accordingly. They're wanting other people to deny their own perceptions of reality and conform with their perception of reality. They want women to do that, and they're also increasingly in schools, children are being forced to do that as well. So that entitlement erodes women's sex-based rights and girls' sex-based rights, undermines the safeguarding of women and children, and it undermines the safeguarding of vulnerable adults as well. I think that the existence of a so-called right in law for someone to be treated as if they had changed their sex is a fundamental contradiction in relation to protecting women, their sex-based rights, and to protecting sex-based rights across the board, and to safeguarding those who are vulnerable to predators. I just want to say something briefly about the Gender Recognition Act and the European Convention on Human Rights. The GRA was introduced after the case of Goodwin in the UK, which was a 2002 case in which the court found that the UK was in breach of Article 8, the right to private and family life, and Article 12 of the Convention. Article 12 is the right to marry and found a family. At that time, there was no single-sex marriage and no civil partnership. So Mr. Goodwin, or Christine Goodwin, as he called himself, could not marry his partner. They said that the UK was discriminating against, and they used this phrase, post-operative transsexuals. They said there should be a provision for post-operative transsexuals, and they're very specific about that, to change their gender in law. As Sheila's already said, people didn't talk about transgender in those days. Christine Goodwin had the operation. He was post-operative. When the legislation was introduced, it didn't require any operations to have taken place. Now, that was some time ago. Since then, the European Court of Human Rights decision-making has moved further and further in the direction of saying that member states of the European Convention are required to allow for some form of recognition of change of gender or change of sex in law. And in the 2022 case of AD and others against Georgia, the court stated that under Article 8, member states are expected to provide what they called quick, transparent, and accessible procedures for changing the registered sex marker of transgender people. The court said that this is a positive obligation on states, and it has a very narrow margin of appreciation. What that means is the margin of appreciation is something that exists whereby the courts will allow some states a certain amount of leeway in the extent to which they comply with their decision making, depending on their existing legal and cultural traditions. On some issues, there's a very wide margin of appreciation. Tax law is one of them. On some issues, there's a very, very narrow margin of appreciation, which means they won't allow for much diversion. And they said this was a case of a very narrow margin of appreciation. If the GRA was repealed, then that could be challenged in the European Court of Human Rights. It's likely, I think, the challenge would be upheld. And if it went that far, it's possible for the bodies of the European Court to expel a state, to remove a state from membership of the convention. They haven't done that very often. The only state they've done that to so far, to my knowledge, is the Russian Federation because of the invasion of Ukraine. So something very, very serious, but it's a possibility. And that raises issues and problems for women, I think, because the European Convention has some important safeguards for women in relation to male violence, in particular Article 3, under which domestic abuse, for example, sexual violence are at the minimum inhuman and degrading treatment, and in some cases, such as sexual violence during warfare, defined as torture. So Article 3 provides important protections for women, and so do some aspects of the Article 8 decisions. So that would be a dilemma. But it's a very long way down the road. Thinking about Gender Recognition Act and thinking about gender identity more broadly may have changed a lot by the time any possible repeal came about. And I think we'd have to deal with that if it ever arose when we came to it. But I'm just noting that is an issue in regard to potential repeal of the Gender Recognition Act. Because now the concept of gender identity and the idea that changing gender is a right has become very, very deeply embedded in the thinking of the European Court of Human Rights. That's all I wanted to say. Thank you.